This is part 3 of contracts. We're starting with counteroffer and the mirror image rule under common law. Under common law, acceptance must mirror the terms of the offer. So terms of acceptance must mirror terms of the offer. Modification and or addition of terms operates as a rejection, and counteroffer, again, remember the ability to modify terms or make a counteroffer in an option contract setting. Mirror image rule under the UCC. The UCC does not follow the mirror image rule for counteroffers. Generally, an agreement is made under the UCC or between merchants by an exchange of forms. Therefore, offer and or acceptance may contain additional and or different terms. Where acceptance includes additional terms, this is the last shot rule under the UCC. These terms are automatically included unless these terms materially alter the original contract. The offer expressly limits acceptance to terms of the offer, or the offeror already objected to additional terms and or objects within a reasonable time. Where the acceptance includes different terms. Again, previously it was additional terms. This is where acceptance includes different terms. This is the knockout rule under the UCC. Different terms in an offer and an acceptance nullify each other and knock each other out of the contract. The court may then apply gap-filling provisions. Consideration is a detriment to the promisee. It's irrelevant whether there is or is not a benefit to the promisor. Detriment may be a promise to do something, a promise to refrain from doing something that you are legally permitted to do. Performance of some act or refraining from performing some act. Adequacy of consideration. Generally, you cannot challenge a contract on the grounds of inadequate consideration. Performance of a pre-existing duty is not consideration. Partial payment of a liquidated debt is not consideration unless that is the result of a compromise. It's kind of an accord and satisfaction. Past consideration is not consideration. You should do this for me now because I did that for you then. That's not adequate. Modification of a contract. Generally, under common law, modification of an existing contract must be supported by consideration, additional consideration. Under the UCC, this does not require, modification does not require additional consideration under the UCC. Modification only requires good faith, and good faith is fair dealing in accordance with reasonable commercial standards. Again, accord and satisfaction in the context of consideration. An accord is a new agreement where one party to a contract agrees to accept different performance. Consideration is generally required, such as where the creditor agrees to accept less than when an amount is in dispute. As the accord is a new agreement, satisfaction is performance of the accord agreement. Now, breach of an accord by a debtor will allow the creditor to pursue either the accord agreement or the original contract. Looking at requirements and output contracts and consideration in that context, a requirement contract is where the buyer agrees to fill all of their requirements and or needs from the other party, the seller. And an output contract is where the seller agrees to sell all of his output to the other party buyer. There is consideration here because it is a legal detriment. If one of these parties goes out of business, it is a detriment to the other party. Under the UCC and requirements and output contracts, quantities may not be unreasonably disproportionate to stated estimates. If there are no estimates, prior outputs and requirements are used as a guide to determine what is unreasonably disproportionate. Looking at the material benefit rule and promises that are binding without consideration, where A performs an unrequested service for B, that constitutes a material benefit to B. Modern trend permits A to enforce a promise of payment against B, though this is not enforceable at common law due to lack of consideration by B. And it's enforceable only to the extent necessary to prevent injustice. An example is that you leave your house, you have a dog, your dog is at home, your dog escapes and gets hurt or just escapes. Your neighbor sees this, brings the dog into their house, shelters the dog, or mends the dog. You may be liable to your neighbor for mending the dog or storing the dog. Looking at detrimental reliance or promissory estoppel, again, promise is binding without consideration. Promise may be binding if the promisor reasonably expected to induce an action and or forbearance by a promisee and or third person. The promise does induce such an action or forbearance, and injustice can only be avoided by enforcement of the promise. Now, this applies in the context of subcontractor bids. Subcontractor bids are outstanding offers. This is an agreement not to revoke the offer, and it is enforceable. So the general contractor relies on that subcontractor bid. They go forth and they put a bid forward for a construction project. The subcontractor then goes to withdraw that bid. The subcontractor may be held to that bid. Enforceability of contracts. There are void contracts and voidable contracts. Void contracts are contracts that cannot be enforced. It's as if no contract existed. Voidable contracts are valid contracts unless one party moves to avoid it. You also have unenforceable contracts. This is a valid contract that cannot be enforced. One party refuses to carry out the terms. That completes part 3 of contracts.